So there's been some interesting developments on the wage and hour side with the Federal Department of Labor. And the main law there, of course, is the Fair Labor Standards Act. It's been around since the late 30s. It talks about your minimum wage and your overtime. One of the big issues that employers face is which employees are subject to those minimum wage and overtime requirements, and which employees are exempt. Now, the current law is you've got two pieces. You've got your salary threshold and you've got your duties test. And in order to be exempt and not get overtime, you have to make more than that exemption, which right now is around $34,000. And you have to have those white-collar job duties. So it's usually a professional, administrative, or managerial types of work. Folks that supervise, folks that do professional work. Now, the big change that's coming down the pike is just a few weeks ago, there was a new proposed rulemaking from the Department of Labor. And that's going to actually move that exemption threshold up to around 50,000. And the reason I say around 50,000 is because it's not a set number. It's going to be pegged to wage data. It's going to be pegged to a percentile of wages for whatever that year is, and then every year it's going to change. Probably means it will increase each year. But in the immediate future, whenever this is passed, it's going to mean that a lot more folks are going to be protected in the workplace, and they're going to have the minimum wage, and they're going to have to be paid overtime. Either that, or they're going to have to change. Employers are going to have to change the way that they pay certain workers. So, in addition to the whole issue of exemptions, there's also the issue of who's covered under the Fair Labor Standards Act, and that comes down to how do you decide who's an employee and they're covered, or who's an independent contractor. Independent contractor's not going to be covered. And that's a different standard than is used in some other employment laws. And it's a very broad standard. And what's come out, again, recently, just within the past week, is a new interpretation from the Department of Labor. And the Department of Labor is taking the position that almost everyone is an employee. And that's probably overstating their case a little bit. But there is some good legal support out there from the Supreme Court and other federal courts that says, yeah, it is a broad standard. And the standard is the employee economically dependent on the employer? And there's various factors that go into that. But it really comes down to, in a lot of cases, the entrepreneurial nature of what that worker's doing. Are they investing a lot of money in their venture? Are they risking a loss? Do they have multiple clients who they work with, not just this one employer? Are they making business judgments? Are they making decisions on who to hire on their own? If they're doing those things, they're more likely to be an independent contractor versus an employee who's really just dependent on that one employer for their livelihood.